Good morning, ladies and gentlemen. Welcome back to Bexar County Court at Law Number 6 in the Bexar County Veterans Treatment Court. I'm Judge Wayne Christian. Representing the state in all matters today will be Mr. Eddie Villarreal and Mr. Arthur Reed. Representing the Bexar County CSCD will be Ms. Susan Gross, who I will swear at this time. Ms. Gross, raise your right hand. Do you swear the testimony you're about to give to be the truth, the whole truth, and nothing but the truth? So help you God?
Yes, sir, I do.
Thank you. Cases we have set for hearing today are all motions to revoke probation. The first one is cause 622782 and 658662. State of Texas versus Angelica Hetzer, represented by Mr. Keith Engelkey. And I have paperwork on all that. Mr. Engelkey, are you ready to proceed?
Yeah, Your Honor.
Thank you very much. Next case I have set is cause 640-941 and 642-648, State of Texas versus Alexis Garcia, represented by Mr. Stephen Harkowitz. Mr. Harkowitz, are you ready to proceed?
Yes, Your Honor.
Thank you. I also have cause 656-968, State of Texas versus Myra Gonzalez, represented by Mr. Ruben Flores. Mr. Flores, are you ready to proceed?
I am, Your Honor.
Thank you. Next is cause 676-957, State of Texas versus Debbie Telementas Stokes, represented by Mr. Efren Torres. Mr. Torres, are you ready to proceed?
Your Honor, he has not come in yet. Remember, he had that other issue.
Okay, all good. We'll wait for Mr. Torres.
Mhm.
The next one I have on my list is cause 663354, State of Texas versus Abigail Siebers, represented by Mr. John Kuntz. Mr. Kuntz, are you ready to proceed?
Hey, Judge, we are not, but I would like to discuss things with you and the prosecutor when you're done with your other matters. I think we're very close to a resolution. We just need to discuss something with you.
Okay, I don't have your paperwork yet. Is there a reason for that?
What paperwork? I'm sorry.
Pat, do we have paperwork on Mr. Siebers and I just don't have it?
Yes, Your Honor, and I believe I sent it, but I'll double check.
Let me look. Stand by.
Sure.
I thought we did, Your Honor. Let me just, like I said, look.
All things are possible.
Yes, Your Honor, I sent that to you at 7:50 this morning.
Oh my goodness. All right, I'm gonna look for that in a minute. John, stand by and we'll get back to you. Let's finish our docket call here and we'll go from there. Thank you.
No problem. Thank you.
And next one on my docket appears to be cause 609734, State of Texas versus Arthur Sanchez, represented by Ms. Alma Barrera, or excuse me, Benavides. Ms. Benavides, are you ready to proceed?
Yes, Your Honor.
Thank you. Next on my docket is cause 653301, State of Texas versus June Eileen De Leon, represented by Mr. Robert Gebbia. Now, it used to be Cecil Baines. Does that sound right, Mr. Gebbia?
Your Honor, Mr. Gebbia was signed in, and then he had Mr. Daniel De La Garza to stand in for him. They both have left, and Ms. De Leon has never signed in, Your Honor. Again, he was requesting, since he just put in his notice of retained counsel, he was requesting 2 weeks, Your Honor.
Well, can't educatedly do any decisions without having the attorney and the defendant here, so we'll wait and see if they come back.
Okay.
I have on my list cause 638886 and 653434, State of Texas versus Julian Lopez, represented by Mr. Christopher Arce. Mr. Arce, are you ready to proceed?
Yes, Your Honor.
And do I have paperwork on Mr. Lopez?
Yes, Your Honor. I sent that to you at 7:50 this morning.
All right, so I have Siebers and Lopez documents. Let's take about a 2-minute break and let me go find those and get ready on those. Stand by.
And also Ms.
Thank you, Judge.
Talamantes,
Also, what? I'm sorry?
Ms. Talamantes Stokes on that same email.
All right, stand by. Okay, showtime. I apologize for the delay. Let's start with State of Texas versus Angelica Hetzer, 622-782, represented by Mr. Keith Engelke. This is a motion to revoke community supervision. The first document I have, in this case, Ms. Hetzer, Mr. Engelke, is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference that purports to have both your signatures on it. In fact, Ms. Hetzer, is this your signature on this document, ma'am?
Yes, sir.
Thank you. And Mr. Engelke, as attorney for Ms. Hetzer, is this also your signature on this document, sir?
I cannot see the document, but I did sign it.
Thank you, sir. Next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction, unquote. In fact, Ms. Hetzer, is this your signature on this document also, ma'am?
Yes, sir.
Thank you. And Mr. Engelke, as attorney for Ms. Hetzer, is this also your signature on this document?
I signed the document, but I cannot see it right now.
Thank you, sir. Okay. Mr. Engelke, my understanding is that this is going to be an uncontested motion to revoke community supervision. Is that correct?
I believe I have an agreement with the state, or the state has a recommendation.
My understanding under the law is that you can have agreements between the state and the defense, but I'm not bound by them. Do you agree that that's the law?
I do, Your Honor.
Certainly, I'll be happy to listen to your recommendation and or the state's recommendation. And if you all agree, that's fine. I'm just not bound by it. I just need to make sure that both you and Ms. Hetzer are aware of that. Are you aware of that, Ms. Hetzer?
Yes, sir.
Thank you very much. All right. Ms. Hetzer, in clause 622-782 on the motion to revoke community supervision, how do you plead, ma'am?
Guilty?
Normally it's true or not true?
Oh, true. True.
True. Fair enough. Ms. Gross, would you please advise the court on the parties of the status of Ms. Hetzer's probation? I remind you, you're still under oath. And Ms. Hetzer, you're good. I was just gonna say, turn your microphone off to get jail background noise. Thank you. Anybody else with their microphone on at this time, please turn it off because we're getting background noise unless we speak to you. Thank you. Go ahead, Ms. Gross.
Yes, Your Honor. Good morning. Ms. Hetzer has performed poorly on probation in that she missed her last 2 months of reporting, and we've not seen her since July 15th, 2021. This is her first violation report, first MTR. This case did expire on September 18th of 2021. She does have a new theft charge pending. However, this offense did occur prior to the granting of probation. The offense was on July 27th, 2020, and she was placed on probation March 19th, 2021. She has made no payments towards her fees and has a balance of $675. We have no record of any of her 24 hours of community service having been completed. She has one negative drug test and one positive drug test for marijuana. We have no record of enrollment or completion of a theft class. And she has no prior criminal history other than the charge that is pending. And her officer is recommending revocation.
Mr. Engelke, over to you.
My client has 4 dependents, and at least one of their children has severe asthma. It's difficult for her to attend probation and to attend classes because of those problems. She does have a job. In fact, her boss called me a few evenings ago.
And what are you requesting, Mr. Engelke?
I'm requesting that the motion be denied and she be placed back on probation.
Okay. State recommendation?
State recommends weekly UAs and substantial compliance within 10 days.
I got a question for the state. How are we going to get weekly UAs if I can't get her to report in the first place?
Well, that's a really good question, Your Honor.
All right. Well, thank you for your recommendation.
And Judge, if I may remind the court, this case did expire September 18th, 2021.
And Susan, the fine amount on this case, if you know, is $200, is my understanding.
Yes, Your Honor, that is correct.
Ms. Hetzer, on cause 622782, the court accepts your plea of true. I grant the state's motion to revoke your community supervision. I sentence you to 6 months in the Bexar County Jail. It says a $200 fine plus court costs, credit for time served, time and money to run concurrent. State, do I have your permission to take into consideration clause 658662 since she's being sentenced on 622782?
Yes, Your Honor.
And Mr. Engelke, would that be okay with the defense?
It would, Your Honor.
All right, well, we're going to do that. And I'm going to recall all pretrial bond requirements, conditions, and warrants. I show that Ms. Engelke gets credit for 13 days is what my records reflect.
Excuse me,
Okay, anything further from the state of the defense?
Judge, who is getting credit for the 13 days? I've never heard my name.
You're right. It's Ms. Hetzer. I apologize, Mr. Engelke. All right, anything further from the state of the defense on Ms. Hetzer?
Nothing from the state, Your Honor.
Nothing from the defense, Judge.
Good luck, Ms. Hetzer. Thank you, Mr. Engelke. Okay,
Thank you, Judge.
next I have Ms. Garcia. This is cause number 640-941 and 642-648. We'll start with 640-941. State of Texas versus Alexis Garcia.
Can
These
I
are
say
both.
something?
I beg your pardon?
Can I say something? I mean, I talked to my probation officer. The last month I didn't, and I told
Hang
her.
on just a second, Ms. Hetzer. Let me find your paperwork again. Stand by. All right, back on the record on 622-782, State of Texas versus Angelica Hetzer. With Mr. Engelke's permission, Ms. Hetzer, you're welcome to speak. Is that okay with you, Mr. Engelke? Mr. Engelke still with us?
I believe he has left, Your Honor.
All right, would you text Mr. Engelke and ask him to come back on Zoom because Ms. Hetzer wants to speak? Do we have a cell number on him?
Hold on, Your Honor. Let me see if I have a.
Ms. Hetzer, we can't chat with you without having your attorney present. So if you just stand by, turn your microphone off, we'll wait for your lawyer to come back. Okay, so we'll stay on standby for Ms. Hetzer again. Back on Ms. Garcia. And cause 640-941 and 642-648. These are both, no, 640-941 is a motion to revoke community supervision. The first document I have on this case is entitled Defendant's Consent to Motion to Revoke Hearing Through Video Conference that purports to have both Ms. Garcia and Mr. Harkowitz signatures on it. In fact, Ms. Garcia, is this your signature on this document, ma'am?
Yes, sir.
And Mr. Harkowitz, as attorney for Ms. Garcia, is this your signature on this document, sir?
It is, Your Honor.
Thank you. The next document I have in cause 640-941 is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction. In fact, Ms. Garcia, is this your signature on this document also, ma'am?
Yes, sir.
And Mr. Harkowitz, as attorney for Ms. Garcia, is this also your signature on this document?
Yes, Your Honor.
This is a motion to revoke community supervision in clause 640-941. My understanding, Mr. Harkowitz, is this going to be an uncontested motion to revoke community supervision? Is that correct?
That's correct, Your Honor, with explanations.
Fair enough. Ms. Garcia, in clause 640-941 on the motion to revoke community supervision, how do you plead, ma'am?
Judge, before she pleads, I just ask clarification.
Sure.
I had last week requested copies of the MTRs, and I have before me MTRs dated December 15th, 2021 in both these cases. Is that the motion that's before the court?
No,
Go ahead, Ms. Gross.
there was an amended filed yesterday.
Okay,
That's
and
not on.
I have not received the amended one then, and just ask what may have been amended so I could determine whether I'm still ready.
It is gonna be the new theft case and additional months of non-reporting from December 2021 through March 2022.
Let me ask this, Ms. Gross. I don't have a first amended motion to revoke community supervision on clause 6400941. Am I supposed to?
Yes, I emailed it to you yesterday.
Can we get Mr. Harkowitz a copy of both these? I guess there's a first amended on both of these cases, right?
That is correct. I
And-
can email both of you a copy if you give me just a minute, and I'll need Mr. Harkowitz. If you can please type your email into the chat, I will email that to you post haste.
And we'll just defer proceedings for a little while until everybody gets copies of the correct documents. Thank you. And let's see. Next on my list is clause 6566968, State of Texas versus Myra Gonzalez.
Judge, I need a minute to take care of this.
That's a good point. Go ahead.
The email has been sent to the judge, both DAs, attorney, and Ms. Benavides.
Pat, why don't you see if Mr. Harkowitz and his client would like to go into a chat room so they can discuss that stuff. Would that be good for you, Mr. Harkowitz?
That's fine, Judge.
So please send Ms. Garcia and Mr. Harkowitz into a chat room.
Yes, sir.
And I'm still fetching documents here.
Go into room 5.
Okay, let me run in the next room and see if it's printing. Okay, back at the ranch, still on Zoom. Back on the record on cause 656-968, State of Texas versus Myra Gonzalez, represented by Mr. Ruben Flores. This is a motion to enter adjudication of guilt and revoke community supervision. The first document I'm looking at is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference that purports to have both Ms. Gonzalez and Mr. Flores' signatures on it. In fact,
Judge, well, they're not here.
where are they?
I presume they're in a breakout room.
Oh,
I'm right here, Judge.
they're there. They're there, Your Honor.
We're back.
Where's Miss Garcia? I don't see her.
No problem, guys. Let's start over. This is cause number. We have both Mr. Flores and Ms. Gonzalez, correct?
Yes, Your Honor.
Gonzalez. And I'm looking for Mr. Flores.
Yeah.
Yep, and I see Ruben. All right. It's cause number 656-968, State of Texas versus Myra Gonzalez. This is a motion to enter adjudication of guilt and revoke community supervision. The first document I'm looking at is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference that purports to have both the signatures of Ms. Gonzalez and Mr. Flores on it. In fact, Ms. Gonzalez, is this your signature on this document, ma'am?
Yes, Judge.
And Mr. Flores, as attorney for Ms. Gonzalez, is also your signature on this document. Thank you. And the next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is an adjudication of guilt following a deferred adjudication and the defendant has a limited right of appeal. In fact, Ms. Gonzalez, is this your signature on this document also, ma'am?
Yes, Judge.
And Mr. Flores, as attorney for Ms. Gonzalez, is this also your signature on this document?
Yes, Your Honor.
Once again, this is a motion to enter adjudication of guilt and revoke community supervision under cause number 656-968. My understanding, Mr. Flores, is that this is an uncontested motion to enter adjudication of guilt and revoke community supervision. Is that correct?
Correct, Judge. It's a clear, true with explanations.
And I'm having a hard time understanding you. Can you turn up your volume a little bit?
Yes, Judge. This is a clear, true with an explanation.
Fair enough. Ms. Gonzalez, in cause 656-968 on the motion to enter adjudication of guilt and revoke community supervision. How do you plead, ma'am?
True.
And we'll accept that as true with an explanation. Would that be correct, Mr. Flores?
That's correct, Your Honor.
Fair enough. Ms. Gross, would you please advise the court and the parties of the status of Ms. Gonzalez's probation? I remind you, you're still under oath.
Yes, Your Honor. Ms. Gonzalez was reporting as directed. However, she did miss reporting last month. The last time we saw her was February 11th, 2022. Her case is paid in full. She's completed all 48 hours of her community service, as well as her DWI education, victim impact panel, and CATSNP programs. She is currently on Smart Start Mobile testing at 6 times per day. She has had 7 skip tests and 2 high BRACs, the first one occurring on February 11th, 2022 at 11:55 p.m. where she blew a .022, and the second at February 12th, 2022 at 12:09 a.m. .020 with no retest, and she did not blow to clear until 2:52 a.m. She has been in lockout since February the 6th, 2022 for a period of 2 days. She has had 8 negative drug tests. She failed to submit to drug testing on 1 occasion. And of course, she did have the 2 alcohol violations on the Smart Start. January 12, 2022, you put her on weekly drug tests, and she has missed 8 of those weekly drug tests to date. This is her 3rd violation report, 3rd MTR. She has no criminal history. Her case expires May 26, 2022, and our officer is recommending revocation.
Mr. Flores, what are you requesting?
We're asking that she be continued on probation, Judge.
This is her 3rd MTR, did you say, Susan? 3rd?
Yes, Your Honor. And her original fine was $850.
Mr. Flores, this is Ms. Gonzalez's 3rd MTR. She's had really good lawyers in the past to last this long. But B, I can't stop her from drinking. She's still offending. What do you say to that?
Judge, let me give you an explanation. First and foremost, she accepted responsibility, Judge. It was on February 11th that she had a drink. She was out for Valentine's Day with her boyfriend and she had a drink. And it was a single drink. As far as the smart start devices, the first violation is alleged to have happened on October 4th, 2021, and I'd ask the court not to consider that because we did have an MTR hearing on January 12th that addressed that particular miss. On the other one, Judge, she missed 6 tests. What happened was she paid her device through the device, and if you know how the device works, it gives you a window of about 72 hours to pay your monthly payment. She made that payment and somehow the system didn't read the payment and locked her out on a Sunday. So she missed a whole day of testing because she couldn't call the company until Monday to get them working on that. As far as the one violation where she did not submit to urinalysis that is alleged on this MTR, it was on January 19th. She provided proof to her probation officer on January 16th that she had COVID and rescheduled her UA for the 24th, which was the following Monday from the 16th. So as far as the drinking, Judge, it was a bad judgment on her part, but she is substantially in compliance. The other violations are technicals that I believe she has good explanations for, and we'd ask that you continue her on deferred, Judge.
Mr. Flores, how long have you been practicing law as a criminal defense counsel in Bexar County, San Antonio, Texas?
26 years have come May, Judge.
So does that mean you've probably known me for plus or minus 26 years?
That is correct, Your Honor.
Probably. Would you agree?
I would agree, Judge.
Have you ever seen me have anybody on any probation ever that had 3 MTRs ever since you've been practicing with us? I can tell you the answer to that. The answer is no. You've never seen it because it's never happened. Ms. Gross, you've been with us for what? Oh, on and off 17 years. That sound right?
Actually 32 with a 11-year vacation.
But with me, we had 6 years in county court 9, and now we've had 11 years or 12 years plus in county court 6. Have you ever seen me give anybody 3 MTRs?
Not on a DWI or obstruction. No, sir, I have not.
Ms. Gonzalez, would you have to agree with me that I've given you every chance on the book on this probation? If this is your 3rd MTR?
The second,
Deferred adjudication on the first 2.
I'm sorry.
I said I didn't even take away your deferred adjudication. I left you on deferred adjudication through 2 MTRs. I think you had really good lawyers earlier. I don't know who they were. They were probably Mr. Flores.
Yes, Judge, it was. The second MTR, though, I don't even believe should have been an MTR because it was an MTR for a positive drug test, and it turned out that it was a false positive drug test.
Ms. Gross, do you know anything about a false positive drug test?
I'm looking it up right now, Your Honor.
You mean false positive for alcohol?
It was a drug test that came through for methamphetamine, and then it came back as a false positive. But that's what caused me to go into the second MTR.
Judge, I am reviewing the second MTR, and there was an allegation of methamphetamines. But in addition to that, there were multiple other violations, to include failure to submit to drug testing, submitting a diluted sample, failure to comply with her device, in that she skipped 4 test windows. Then again, that she skipped another test, and that she failed to comply with the weekly UAs as you had ordered previously. So there were multiple violations, even if you did eliminate the positive for amphetamines, methamphetamines. And even with that, I do not show that there was a confirmation done on that. Oh, wait a second. It's hiding down here. Hang on.
Well, the ultimate issue is she wasn't revoked by virtue of that motion to revoke deferred adjudication, probation, adjudicate guilt, and revoke community supervision, right? I did not revoke her for whatever reason. We all agree. She's still here today on her 3rd MTR. Is that correct?
Yes, and no, you did not revoke her. You gave her an opportunity by merely amending her conditions of probation to give her yet another chance for the other violations that were on the motion to revoke. And in that case, you continued her. And at that time, you didn't even make any changes to her conditions. You continued her on the Smart Start mobile device at 6 times a day and with her weekly UAs. And she did not comply with those weekly UAs. And in regards to her alleged defense for the COVID issue, I do show that there is a positive, a photo of a positive result from the testing. And that was on January 16th. So
okay. Let me stop you. Let me just stop you. Thank you very much. We're going forward on the 3rd MTR today, Ms. Gonzalez. Anything that may have happened in the past, we've already looked at and I've already made a decision on. So that's not really an issue at this point in time. State, what is your recommendation on Ms. Gonzalez?
Well, Judge, initially I was going to recommend scram and substantial compliance, but after hearing what Ms. Gross had to say, I am going to change my initial recommendation and recommend revocation.
Anything further, Mr. Flores?
The only thing I would add is that the miss on the UA was the COVID issue, and that's the only one that's alleged. So I don't know what other UA's probation is saying she missed, but the only one alleged in the MTR was when she had COVID. And we'd ask that you continue here on deferred, and in the alternative, revoke her probation and put her on community supervision, Judge.
Okay, thank you. Ms. Gonzalez, in cause 656-968, the court accepts your plea of true with an explanation. I grant the state's motion to revoke your deferred adjudication probation. I adjudicate you guilty of the offense of obstruction of a highway. I sentence you to 90 days in the Bexar County Jail instead of the 6 months I could sentence you to. And I assess a $1,000 fine plus court costs, credit for time served, time and money to run concurrent. You're to report to the Bexar County Jail at 9:00 a.m. on Monday, April 18th, 2022. Is that correct? Yeah. To serve your sentence, I'm going to recall all warrants and bond conditions from pretrial services, and I do not object to the sheriff giving you maximum credit, which is normally 3 for 1 for your sentence. Anything further from the state of the defense on this?
Nothing from the state, Your Honor.
Judge, if I can ask.
With your attorney's permission, Ms. Gonzalez, certainly.
I'm sorry, instead of the time in jail, isn't there any way I could do I believe it's called the scram, the ankle monitor or anything else, and other than going?
If I felt like I could rehabilitate you and get you to actually stop drinking, we would have something to talk about. That ship has sailed. This is your third motion to revoke probation. This court has done backflips trying to help you and give you chance after chance. That time is over. Talk to your attorney. I couldn't have been any nicer to you through this probation. Mr. Flores, if you'd like to go in a breakout room with Ms. Gonzalez and chat with her, you're welcome to do so, sir.
Judge, I'd ask the court to consider work release for her, Judge. She is gainfully employed.
There's no such thing as work release right now due to COVID, is my understanding. Feel free to research that. In the past, before COVID, we had the option of work release, which meant that a defendant would spend the night in the jail and then go to work during the day. That apparently is not available now, and that has turned into full house arrest, GPS, where they stay at home. And we're not going to do that. So feel free to research that. If that changes, let me know.
Your Honor, Larry checked, our bailiff checked yesterday, and there is no work release.
That's what I thought. All right, Ms. Flores, do you want to go in a breakout room with Ms. Gonzalez or not? Doesn't matter. Doesn't, any way you want to do it, it's fine with us.
Call her on the phone, Judge. I got good contact with her.
Okay, I missed that. Is that a yes? You want to go in a breakout room or no, you don't?
No, Judge, I'll talk to her on the phone. I have her number.
Thank you, Mr. Flores. Thank you, Ms. Gonzalez. Your release.
And Judge, I believe we have Mr. Harkowitz back. If
Oh.
you wanted to review the Alexis Garcia.
Back on the record on class 640-941 and 642-648. I have received, well, I already had one. I have received a quote, first amended motion to revoke community supervision dated April 12th, 2022 that I didn't have before. Mr. Harkowitz, have you had a chance to review those documents?
I have, Your Honor, and I would just tell the court that other than the number one violation, we would be prepared to proceed on the MTR.
And what is the number one violation?
A felony theft case pending, I believe, out of the 290th.
State, you don't plan on going forward on that condition and trying to prove it up in a motion to revoke probation hearing, are you?
That's correct, Your Honor. We will not try to prove up a new number one.
Would the state like to move to waive that condition then under the circumstances?
Yes, Your Honor.
No objection from the defense, that will be granted.
No objection, Your Honor. So my
that's
client
on
will
both
be
cases.
prepared to plead true with explanations.
And that's on both cases, 640-941 and 642-648 on the first amended motion to revoke community supervision. So that being said, back on 640-941, and I'm not sure where we stop. Let me just start all over and we'll just go through it real quickly if that's okay with everybody. This is class 640-941, State of Texas versus Alexis Garcia. This is a first amended motion to revoke community supervision. The state has moved to waive the allegation of condition number one, alleging a new offense, and the court has granted that so that it will not be considered by the court. This is first amended motion to revoke community supervision. Otherwise, the first document I have in this case is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference, and allegedly signed both by Ms. Garcia and Mr. Harkowitz. In fact, Ms. Garcia, is this your signature on this document, ma'am?
Yes, sir, it is.
Thank you. And Mr. Harkowitz, as attorney for Ms. Garcia, is this also your signature on this document in clause 640-941?
It is, Your Honor.
And in clause 642-648, Ms. Garcia, Mr. Harkowitz, I have the exact same document, except obviously numbered for the other case. Is this your signature on the second document also, Ms. Garcia?
Yes, it is.
And is this your signature on the second document on 642-648 also, Mr. Harkowitz?
Yes, Your Honor.
Thank you. The next document I have in clause 640-941 is entitled Trial Court Certification of Defendant's Right of Appeal. And there's exactly the same document on clause 642-648. And my document is marked, quote, is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction. In clause 640941, is this your signature on this document also, Ms. Garcia?
Yes, it is.
And in clause 642648 on this document entitled Trial Court Certification of Defendant's Right of Appeal, is this also your signature on this document? It's the same document for both cases. I've just given you both numbers.
Yes, Your Honor.
Okay. And Mr. Harkowitz, as attorney for Ms. Garcia, is this your signature on the trial court certification of defendant's right of appeal document in both cases, including clause 640941 and 642648?
Yes, Your Honor.
And my understanding, Mr. Harkowitz, is in clause 640941, this is going to be an uncontested motion, first amended motion to revoke community supervision. Is that correct?
It is. That's correct, Your Honor.
All right, Ms. Garcia, in clause 640941, on the first amended motion to revoke community supervision, how do you plead, ma'am?
True.
Thank you. Ms. Gross, would you please advise the court and the parties of the status of Ms. Garcia's probation in clause 640941? I remind you, you're still under oath.
Yes, Your Honor. Ms. Garcia's performed very poorly on probation in that she only ever reported one time. We last saw her on September 2nd, 2021, which was for an MTR hearing, and she never reported again after that. Prior to that, we saw her on July 14th, 2021. This is her second violation report, second MTR. She has not made any payments on this case and has a balance of $20. We have no proof of completion of any of her 24 hours of community service. She has had 5 negative drug tests, failed to submit on 7 occasions. She did complete a theft class. However, we have no proof of enrollment or completion of the drug offender education program. Her prior arrests do include a theft 100 to 750, which was dismissed, a theft 100 to 750, which is the other motion to revoke, which we will be hearing momentarily. And she has a new case pending, which is a theft under $2,500 enhanced, which to my understanding is awaiting indictment. Her officer is recommending revocation. However, should the court consider keeping her on probation, the officer is requesting that you extend her for a period of 1 year and send her to SATF, followed by aftercare. But if the court wishes to consider that, the new offense would have to be disposed of prior to her being able to go to SATF.
And Mr. Harkowitz, what are you requesting in clause 640941?
Okay, I'm asking Your Honor to continue Ms. Garcia on probation. Certainly if the court wants to extend, that would be appropriate. Ms. Garcia tells me that she has a pending CPS case, which she understands that if she's incarcerated for an extended period of time, that that's going to put her parental rights at risk. So she's asking for an opportunity to continue on probation, that she's going to have to do a number of services and classes to be compliant with CPS to maintain her parental rights. So she has a lot of motivation right now to comply with what this court is asking her to do. She's telling me that when she was released, that she had difficulty getting in contact with her probation officer, and that she didn't know where to go for the DOEP class. It's my understanding that she's like, I might be mistaken, 22 or 23 years old. Is that correct, Ms. Garcia? How old are you?
I'm 23. I just turned 23.
And that she has 2 young children. So she's really requesting the court to give her an opportunity to work with CPS to try to get her kids back, which would entail doing what this court requires her to do. And obviously CPS, would want her to be drug-free. So obviously she needs to demonstrate both to CPS as well as to this court that she's abstaining from any illegal substances. If the court's not inclined, I'd ask to keep her on probation. I'd ask the court to maybe consider time served, and given the fact that she's also in jail on that felony theft case and still has that hanging over her head.
State recommendation on Ms. Garcia in clause 6400941, please.
State recommends revocation, Your Honor.
Does anybody have a cause number on the felony case?
Your Honor, I believe that's a night bag. I can find it for you.
It's currently a CM number, Charlie Mary number 090719.
Thank you, Ms. Gross.
Ms. Garcia in clause 6400941. The court accepts your plea of truth and explanation. I grant the state's motion to revoke your probation. I sentence you to 6 months in the Bexar County Jail. Susan, what was the fine amount on this case? It's not on my document.
Judge, it was $300.
$300 plus court costs, credit for time served, time and money to run concurrent. This case to run concurrent was 642-648 and CM Charlie Mike 090719. Anything further from the state or the defense on Ms. Garcia and 6400941?
Nothing from the state, Your Honor.
Nothing for defense or other.
Thank you. In clause 642-648, Ms. Garcia, on the first amended motion to revoke community supervision, how do you plead, ma'am?
True.
Ms. Gross, is there any variation on the theme between your representation of Ms. Garcia's performance in probation in 6400941 and 642-648?
Yes, Your Honor. The only difference on this case would be in regards to the fees, which you ran concurrent. So she is paid $0, has a balance of $905, is delinquent $855.
And the fine amount on this case was also $300. Does that sound right?
Let me double check on that.
Looks like they pled the same day, so my guess is they're the same.
My papers are sticking together here. Yes, the fine is $300 on this case as well, Your Honor.
What are you requesting on 642-648, Mr. Harkowitz?
I would have been requesting the same thing I requested in the other case, Your Honor, that she be continued on probation or given time served.
And state recommendation for Ms. Garcia on clause 642-648.
State recommends revocation, Your Honor.
Ms. Garcia in clause 642-648, the court accepts your plea of true. I grant the state's motion to revoke your community supervision. I sentence you to 6 months in the Bexar County Jail. It says a $300 fine plus court costs, credit for time served, time and money to run concurrent. This case to run concurrent was 6400941 and CM 090719 and whatever ultimate number that turns out to be. Anything further from the state or the defense on Ms. Garcia in clause 642-648?
Nothing from the state, Your Honor.
Nothing for defense, Your Honor.
Ms. Garcia, I will warn you, I came this close to stacking you, making 2 6-month sentences one-on-one instead of running them concurrent. So if there are any more problems in a misdemeanor arena, you're coming right back to County Court 6 and we will remember you. Please do not come back to County Court 6. Mr. Harkowitz, you're the only one that convinced me not to zap her. So +10 for you. But please have a little chat with Ms. Garcia about future issues. Life starts over today. Good luck, Ms. Garcia. Thank you, Mr. Harkowitz.
Thank you so much.
Okay. Done. And what was our status on Ms. Hetzer and Mr. Engelke? Did we do that one?
Yes, Your Honor.
She wanted to talk to you, Judge, so Pat was trying to reach out to the attorney.
That's what it was. Did we get in contact with Mr. Engelke?
Your Honor, I sent him both a text and a email.
Okay, is Ms. Hetzer still with us or did they take her
Yes,
back?
Your Honor.
Ms. Hetzer, we are trying to contact your attorney and we have not been successful. I'm going to text him right now if you want to hang around a little bit longer and let me see if he responds to me when he hadn't responded to the others. Let's take a break and do that.
Yes, sir.
If I have a number on it, let me see if I do or I don't. And Pat, did you say you have a cell number on him?
Well, Your Honor, I just have a phone number on him. I thought if it went through, it went through. The number that I had is area code 210-342-9668.
And did you try to call that and see what happened?
No, I have not called. I will try.
Why don't you try and call that? That doesn't sound like a cell number though. See if we can get a cell number on him or see if they know where he is. And if you get a cell number, text it to me because I do not have a cell number on him. And Ms. Hetzer will be standing by. Thanks. Okay, we did that one. We did that one. We did that one. Have we heard from Mr. Torres or is he still pinned down in another court? Is Efren Torres with us today? I don't see him on the screen. Mr. Kuntz, we've come to you. Are you still with us?
Hey, Judge. Yes, of course.
You want to go in a breakout room with the DA and me? Is that what you said?
Yes, sir. Please.
Let's go do that real quick.
Thank you.
Your Honor, I spoke with Mr. Engelke and he'll be signing in.
Great, thank you. Mr. Kuntz and the DA and I need to go in a breakout room very briefly.
Yes, sir. Yes, Your Honor. You can go into room 1. Which DA? Arthur?
That'll be me, Pat.
Okay, hold on, Arthur. Let me find you. Because you bounced.
Thank you, Pat.
Go to room 1. And Mr. Kuntz, you can go into, wait a minute, hold a minute. It's not showing room 1 at one time. I don't know whether you, yeah, there you go. The judge will be back. He's just went into a breakout room. He'll be right back.
Is there any way to talk to my attorney in the room?
Excuse me?
Is there any way to talk to my attorney alone?
Yes. Yes, I'll put you in a breakout room.
I didn't have a leave the room button, so I had to search around and be pushing stuff, and finally it came up. So we're okay. We're good. Okay, this is cause number 663354, State of Texas versus Abigail Siebers. This is
Abigail, can you turn your screen on and unmute yourself? There you are. Thank you.
This is a motion to enter adjudication of guilt and revoke community supervision. Representing Ms. Siebers is Mr. John Kuntz. The first document I have is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference, which reports to have both Ms. Siebers and Mr. Kuntz signatures on it. In fact, Ms. Siebers, is this your signature on this document, ma'am?
Abigail, are you there? Yeah, there you are. Okay.
Thank you. And Mr. Kuntz, as attorney for Ms. Siebers, is this also your signature on this document?
It is, Your Honor.
And the next document I'm looking at is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is an adjudication of guilt following a deferred adjudication, and the defendant has a limited right of appeal, unquote. In fact, Ms. Siebers, is this your signature on this document also, ma'am?
Yes.
And Mr. Kuntz, as attorney for Ms. Siebers, is this also your signature on this document?
Yes, Judge.
Mr. Kuntz, my understanding is this is going to be an uncontested motion to enter adjudication of guilt and revoke community supervision. Is that correct?
Judge, she'll plead true to the number 2, but not to the other violations because she actually was enrolled at the time the MTR was filed. So
Fair enough. Okay. Ms. Siebers, in cause 663-354 on the motion to enter adjudication of guilt and revoke community supervision, how do you plead, ma'am?
True.
And that'd be true to condition number 2. Would that be correct, Mr. Kuntz?
that's correct, Your Honor.
Fair enough. Ms. Gross, would you please advise the court and the parties of the status of Ms. Siebers' probation? I remind you, you're still under oath.
Yes, Your Honor. Ms. Siebers has been reporting as directed. We last saw her March 25th of 2022. This is her first violation report, first motion to revoke. Her case is paid in full. She has completed all 48 hours of the community service, as well as the victim impact panel and DWI education class. I cannot find any proof of registration or completion of the CATSNP program. She has 1 positive drug test for alcohol, which was confirmed positive by the lab. She has 2 diluted drug tests, 2 negative drug tests. She's currently on Smart Start Mobile testing at 4 times a day. And since December, she has missed a total of 6 tests. She has no criminal history, and her officer is recommending that her Smart Start Mobile be increased to 6 times per day and that she be placed on weekly drug testing.
And Mr. Kuntz, what are you requesting?
Well, obviously, Your Honor, my request would be that you continue her on probation as she's been, but I understand that the court is inclined to make her test 6 times a day. So it's any kindness you can show her would be much appreciated. She is working 7 days a week at her business, at the restaurant she works at. They're very short-staffed and undermanned, and so she's had to take on a huge role there. She will comply with any and all terms that you have. And again, her ignition interlock period was supposed to have expired a couple of weeks ago. And so hopefully if she gets through these next 30 days with the 6 tests a day, we will approach the court again about possibly removing that.
Okay. Pat, off the record on this case, I see that Mr. Engelkey's arrived. Would you please put Mr. Engelkey and Ms. Hetzer in a breakout room so they can chat? And what happened?
They've done that, Your
chatted?
Honor.
All right.
Yes,
As soon as I finish this case, Mr. Engelkey, we get right back to you guys.
thank you, Judge.
Okay, state recommendation on public enemy number 1, Ms. Siebers.
Substantial compliance within 10 days.
You want me to revoke her and then require compliance, or do you want me to not revoke her?
Not revoke her, Your Honor. Continue probation. And
I will walk over to the DA's office and punch him in the face if he's recommending revocation right now. So
Mhm.
Ms. Siebers, in cause 663-354, the court accepts your plea of true to condition 2 on the motion to enter adjudication of guilt and revoke community supervision. I deny the state's motion to revoke your deferred adjudication probation or to continue on deferred adjudication probation with all prior requirements and no sanction, although I have the authority to put you in jail for 30 days to get your attention. Will that be necessary, ma'am?
No.
Oh, another good answer. Altering amending conditions, adding Smart Start Mobile or cranking it up from 4 blows a day to 6 blows a day. That being said, show me 30 clean days without missing any blows at 6 blows a day and no hybrax or alcohol, and I'll return you to 4 blows a day. I won't know if you've done this. You got to let your lawyer know. He's got to let me know. I'll get it confirmed through probation, and we'll crank you back down to 4. I'm putting you on weekly UAs. Show me 4 clean weekly UAs in a row, and I'll put you back on monthly UAs. Once again, I will not know you've done this. Got to let your lawyer know. He's got to let me know. I'll confirm it through probation. And I'm ordering substantial compliance in all other areas within 10 days, which apparently your attorney's already got you doing, but I want her registered for any other program she's required to do. Apparently she's already done a lot. So that's probably superfluous, but anyway. And that's all I got for you. Do you have any questions, Ms. Siebers?
I do not. Thank
And
Right.
I'd like to request if this happens again, you get another lawyer, because your lawyer takes us in the back in those chat rooms and beats us up, tries to throw his weight around. Isn't that right, Arthur? Yes, it is. All right.
whatever I have to do.
Anything further from the state of the defense on Ms. Siebers?
Yes.
Nothing from the state, Your Honor.
Go ahead.
Ms. Siebers, this afternoon, you'll be receiving your alternate amended conditions from me through the Adobe Sign. You need to immediately sign those and send those back, okay? Go ahead and call Ms. Wilcox, let her know what happened today, that you need to be placed on weekly UAs and have your Smart Start mobile increased so that she can take care of that for you. And if for some reason that you can't get in touch with her, then she'll email you all that information this afternoon, but make sure you touch base with her at some point.
Okay.
All right, any questions?
I do have a question. So my pretrial officer is Fabian Ortiz. Do I move any of this information over to him, or how does that work?
The judge is going to lift all the pre-trial requirements. It'll probably take a day for it to get over there because we're going to be in hearings through the afternoon. And by the time it gets to the clerks and then over to pretrial, but he's going to lift all of that.
Okay, so I'm supposed to drug test for him tomorrow. Should I do that and then send it to to Miss Wilcox instead?
No.
Okay.
Because your pretrial requirements are over effective right now.
Got it.
So, right now you 100% belong back to Miss Wilcox.
Okay.
So if Miss Wilcox sets you up on the system today and you start calling tomorrow and it tells you to go tomorrow, then you'll go tomorrow. Okay.
Okay.
All right. So just touch base with her and let her know that you need weekly UAs and your Smart Start bumped up to 6, and I'll send you the paperwork this afternoon.
Got it. Thank you.
You're welcome.
Oh, and Miss Siebers, I would recommend no more NyQuil. What do you think?
Yeah. Yes. Done.
All right. Thank you.
Thank you.
Thank you,
John.
Judge.
May we be excused?
Absolutely. Okay, back on the record on clause 622782, State of Texas versus Angelica Hetzer. The record reflect that after the court had pronounced sentence and released Mr. Engelke and Ms. Hetzer, Mr. Engelke was released and went back to work and left Zoom. And then Ms. Hetzer wanted to make statements to the court and the parties, and I stopped her and had Ms. Benavides track down Mr. Engelke, and he's back. So, Mr. Engelke, my understanding is that Ms. Hetzer wants to make a statement, and she's welcome to do that with your permission as far as I'm concerned.
And she has my permission to do so, Your Honor.
Okay. Ms. Hetzer, you have something you want to tell us?
Yes, I didn't know I had a probation until September. And the reason why I didn't do none of my classes is because I had my kids. I had nobody to watch my kids, and I barely got a job last year in November. That's when I was able to get a job, because I've been waiting for somebody to watch my kids. My kid's father is locked up. He don't get out until next month. But I had talked to her the last month. In August, she told me August was my last month with her, and I didn't talk to her. I didn't go see her because she wanted me to go to the office. Which, how was I able to go to the office? I couldn't even get a job to pay anything. And the classes were $60. All I was barely making diaper money. I don't get how I'm stuck in here for 6 months and everybody else is getting out. And they got more charge than I got.
Anything further, Ms. Hetzer?
I told him I wanted to be on ankle monitor. I don't care what I did. My son has asthma. No one's owed my kids' paperwork but me. My son is missing school. I have CPS out there trying to take my kids.
Mr. Engelke, if you want to go chat with her again in the breakout room, we can do that. If you need to explain anything to her, answer any of her questions. Her comments do not change my sentence.
I believe we've discussed that. This is Ms. Hetzer's first time on probation. She does not know really what to do. And I'm not familiar with the situation. I was not the attorney on the previous matter. However, she does have some problems that do need to be addressed. And I'm not sure that she can run her family. She's the only person in her family to take care of those 4 children. They're all minors. They're all very young. One is just starting school, so she really does need help.
Anything further, sir?
No, sir.
All right. Good luck, Ms. Hester. Thank you, Mr. Anguki. Y'all are released. If you want to go in a breakout room, Pat, do they want to go in a breakout room?
I think that'd be a good idea, Your Honor.
It is a good idea or it's not a good idea?
Would be a good idea.
Okay, Pat, are you with us?
She's muted.
She may have stepped away for a minute, Your Honor.
Okay, well, when Pat comes back, let's ask her to.
There she is. Okay.
Sorry, Your Honor, I moved him into breakout room 3.
Thank you.
Thank you.
Okay. And I've got Mr. Sanchez next. Let's see. Have we done Mr. Telementez Stokes with Mr. Torres? No, we're still waiting on that one.
Mr. Torres is here, Your Honor.
Oh, yeah, then we're good. This is cause number 676-957, State of Texas versus Debbie Telementez Stokes. This is a motion to enter adjudication of guilt and revoke community supervision. Representing Mr. Telementez Stokes is Mr. Efren Torres. The first document I'm looking at is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference, which purports to have both Mr. Telementez Stokes and Mr. Torres signatures on it. In fact, Mr. Telementez Stokes, is this your signature on this document, sir?
Yes, sir, it is.
Or ma'am, I'm sorry. Thank you. Thank you, ma'am. And Mr. Torres, is also your signature on this document?
Yes, Your Honor.
Thank you. The next document I have, Ms. Telementez Stokes, is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is an adjudication of guilt following a deferred adjudication, and the defendant has a limited right of appeal, unquote. Is this also your signature on this document, Ms. Telementez Stokes?
Yes, sir.
And Mr. Torres, as attorney for Ms. Telementez Stokes, is this also your signature on this document?
Yes, Your Honor.
Mr. Torres, my understanding is that this is going to be an uncontested motion to enter adjudication of guilt and revoke community supervision. Is that correct?
Your Honor, for the record's purposes, this is Attorney Rick Ramos of the same firm. I'll be stepping in for this matter.
Great.
How are you, Judge?
Fine, thanks.
Good, Judge. Yes, we will be entering.
So on the record, Mr. Rick Ramos is going to step in for Mr. Efren Torres in clause 676-957, representing Ms. Debbie Telementez Stokes. So thank you, Mr. Ramos, for correcting me. Anyway, back on my question, Mr. Ramos, let's try again. My understanding is this is going to be an uncontested motion to enter adjudication of guilt and revoke community supervision. Is that correct?
Yes, Your Honor. We will be asking the court to not withdraw or enter finding of guilt, but yes, we will be entering a plea of true to the motion.
Very well. Ms. Telementez Stokes, on the motion to enter adjudication of guilt and revoke community supervision in clause 676-957, how do you plead, ma'am?
I'm sorry, what was the question?
The question is, on the motion to enter adjudication of guilt and revoke community supervision in clause 676-957, how do you plead?
True.
Thank you. And Ms. Gross, would you please advise the court on the parties of the status of Ms. Telementez Stokes probation? I remind you, you're still under oath.
Yes, Your Honor. Ms. Telementez Stokes has been reporting as directed. We saw her on March 30th of 2022. She is paid $124 towards her fees. She has a balance of $1,005 and is currently delinquent $31. We have no record of any of her 48 hours community service having been completed. She has, however, completed DWI education, victim impact panel, and we have no record of enrollment or completion in the CATSNP program. She's had one negative drug test. She's currently testing on Smart Start Mobile at 4 times a day, where she has had one skip and one high BRAC, which occurred on March 5th, 2022, and registered at a 0.040 at 5:02 a.m. and she failed to blow to clear until over 7 hours later at 12:19 p.m. She has no criminal history, first VR, first MTR. Her officer is recommending that her Smart Start be increased to 6 times per day and that the court add the CATS intensive outpatient program.
And Ms. Telementis, Stokes, if you turn your microphone off when we're not talking to you so we don't get any background noise, that would be good, okay? Thank you so much. Okay, and she went on probation, looks like late February 24th, 2022. So she's only been on probation about 6 weeks. That sound right?
Yes.
Okay. What are you requesting, Mr. Ramos?
Your Honor, we're asking, we'd be okay with the recommendation of increasing at least for 30 days, Judge. Let's see how she does on that, and we'll be happy to approach the court after 30 days to make sure that there's no violation. And we'd ask the court to keep her on deferred. She has already registered for the CATSNP program as well, Judge, and completed those classes. So we'd ask that she be given the opportunity to go ahead and continue with that, Your Honor.
And Ms. Gross's prior criminal history is Ms. Telementis Stokes a serial killer or anything like that we need to worry about?
No, Your Honor.
No, she has no criminal history or at least no criminal history in Bexar County.
All right. You just can't be too careful. She could be a serial killer in Ohio for all we know.
That's correct.
All right. I got it. State recommendation. What would you like to do?
Your Honor, the state agrees with the probation's recommendation, but we would add substantial compliance within 10 days.
All good. Ms. Telementis Stokes, in clause 676-957, the court accepts your plea of true. I deny the state's motion to revoke your deferred adjudication probation or to continue on deferred adjudication probation with all prior requirements and no sanction at this time, although I have the authority to put you in jail for 30 days to get your attention. Will that be necessary, ma'am?
No, sir.
All right, good answer. Altering and amending the conditions of your probation, modifying your Smart Start mobile from 4 blows a day to 6 blows a day, and adding weekly UAs. That being said, if you go 30-day period of time at 6 blows a day on the Smart Start mobile device, don't miss any blows and no high brax for alcohol, I'll crank you back down to 4 blows a day again. But I won't know you've done this 6 blows things for 30 days unless you tell your attorney, he'll tell me, I'll confirm it with probation, and then we'll crank you back down to 4. On the UAs, show me 4 clean weekly UAs in a row, and we'll crank you and we'll put you back on monthly UAs. But once again, once you do that, you got to let your lawyer know, he'll let me know, and I'll confirm with probation. And I'm also ordering substantial compliance within 10 days. Any programs that you're not already registered for, you may not start them in 10 days, but I want you to be registered for everything you're supposed to be registered for. She's going to do the standard Community Alliance for Traffic Safety New Intervention Program. I'm not going to order intensive outpatient at this time. She's okay on what she's doing. And that's what I got. Mr. Ramos, is that okay with you?
It is, Your Honor. We just want to address one other thing. I don't know if probation had an opportunity to notify the court. However, our client did notify us as well as her PO that there was one missed window on Monday, Judge. She was at work and wasn't able to get to the device to blow into it. However, she subsequently blew into it the following window and there was no alcohol. But we just want to make sure the court is aware of that. That way there's no surprises that we didn't bring that up, or if there's, I don't know if they would file an MTR for that or not, Judge, but that just happened on Monday, if I'm not mistaken.
Are we going to have any more missed windows, Miss Telementis stuff?
No, sir.
Good answer. We're good.
Okay.
Thank you, Mr. Ramos. Thank you, Miss Telementis Stokes.
All right,
Thank you,
Ms.
go ahead.
Telementis, you're going to be receiving an email from me later on today from Adobe Sign with your conditions. It will come later this afternoon. You need to immediately sign that and send it back to me. Go ahead and reach out to Mr. Fonseca and let him know that you need to go on weekly drug testing and that your Smart Start needs to go up to 6 times per day. And then he can give you your new times and he can get you set up on the drug testing. Okay. Do you have any questions? I think she froze.
We'll call her and let her know as well.
Okay.
All good. Thank y'all.
Okay. Thank you, Judge.
You bet. Next case I've got, it's called 609-734, State of Texas versus Arthur Sanchez. Thank you, Mr. Sanchez and Ms. Benavides, for being patient. That being said, this is a, who's talking? I'm sorry. We're good. This is a first amended motion to revoke community supervision. The first document I'm looking at on this case is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference. It purports to have both Mr. Sanchez and Ms. Benavides' signatures on it. In fact, Mr. Sanchez, is this your signature on this document, sir?
Yes, sir.
Thank you. And Ms. Benavides, as attorney for Mr. Sanchez, is this your signature on this document?
Yes, it is, Your Honor.
Thank you. The next document I'm looking at is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision. And the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction. In fact, Mr. Sanchez, is this your signature on this document also, sir?
Yes, sir.
And Ms. Benavides, as attorney for Mr. Sanchez, is this also your signature on this document?
Yes, Your Honor.
Thank you. Once again, this is a first amended motion to revoke community supervision. My understanding, Ms. Benavides, is this going to be an uncontested first amended motion to revoke community supervision? Is that correct?
That's correct, Your Honor. It's going to be a plea of true with an explanation.
Fair enough. Mr. Sanchez, in clause 609734 on the first amended motion to revoke community supervision, how do you plead, sir?
True.
Court accepts the plea of true with an explanation, if that's okay with the defense. And Ms. Gross, would you please advise the court and the parties of the status of Mr. Sanchez's probation? I remind you, you're still under oath.
Yes, Your Honor. Mr. Sanchez has performed very poorly on probation in that he only ever reported one time, which was on March 3rd, 2019. This case did expire August 4th, 2020. He never made a payment. He has a balance of $1,517. His fine in that case is $600. We have no proof of completion of any of his 80 hours of community service. We have no proof of enrollment or completion in the Victim Impact Panel, DWI intervention, or CATSNP programs. He did have one negative drug test, and he was on the Smart Start mobile. And when he was testing, he was at 4 times a day. He had 20 skip tests and no high bracs, but he has been in lockout since September 16th of 2019. His previous arrest history includes a DWI, burglary of a vehicle, assault, bodily injury, criminal mischief, 50 to 500, retaliation, unlawful restraint, resisting arrest, and then this case. The officer is recommending that his probation be revoked.
And Ms. Benavides, what are you requesting?
Your Honor, in speaking to Mr. Sanchez, he's explained to me that his poor performance has been primarily due to the fact that he was a caregiver for both of his parents, and during this probationary period, he has lost both his mother and his father. He is a single parent of a 6-year-old daughter. He lost his job, he lost his ID. And so we're asking the court for two things. We're asking the court to allow him to start his probation all over. In the alternative, Your Honor, since we are not allowed to ask for work release at this time, in the event that he could get a job in the next week or two, we're asking for full GPS house arrest. And so, Your Honor, we're asking if you would do that. He tells me that he's willing to comply with whatever conditions the court imposes on him.
And state recommendation on Mr. Sanchez?
State recommends revocation, Your Honor.
Mr. Sanchez, in clause 609734, the court accepts your plea of true with an explanation. I grant the state's motion to revoke your probation. I sentence you to 1 year in the Bexar County Jail, assess a $600 fine plus court costs, credit for time served, time and money to run concurrent. You're to report to the Bexar County Jail at 9:00 a.m. on Monday, April 18th, 2022, to give you time to get your affairs in order. Recalling all pretrial services, bond conditions, and warrants. Anything further from the state or the defense on Mr. Sanchez?
Nothing from the state, Your Honor.
Nothing from defense, Your Honor.
Good luck, Mr. Sanchez. Thank you, Ms. Benavides.
Thank you, Judge.
And I got a text message from Mr. Gebbia that he is picking a jury trial somewhere. Where did he say he was picking a jury trial? County Court 11. So at some time, Pat, we might want to see if he's really in County Court 11. And now we have cause 6388886 and 653434, State of Texas versus Julian Lopez, represented by Mr. Chris Arce. Cause 638886 is a motion to revoke community supervision. Cause number 653434 is also a motion to revoke community supervision. Mr. Lopez, in both cause 638886 and 653434, I'm looking at two documents, both entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference, both reportedly having both your signature and your attorney, Mr. Arce's signature. In fact, Mr. Lopez, is this your signature on both these documents, sir?
Yes, Your Honor.
Thank you. And Mr. Arce, as attorney for Mr. Lopez, is this also your signature on both these documents, one in cause 638886 and one in cause 653434?
Yes, Your Honor.
The next documents I'm looking at are both the same, and they're entitled Trial Court's Certification of Defendant's Right of Appeal, one in cause 638886 and one in cause 653434. And they are marked, quote, is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions, revoking the community supervision, but not the underlying conviction. In fact, Mr. Lopez, is this your signature on both these documents, one in cause 638886 and one in cause 653434?
Yes, Your Honor.
Thank you. Mr. Arce, as attorney for Mr. Lopez in both these cases, is this also your signature on each of these documents, one in cause 653434, one in cause 638886?
Yes, Your Honor.
My understanding, Mr. Arce, is that cause 653434 is an uncontested motion to revoke community supervision. Is that correct?
Yes, Your Honor.
All right. Mr. Lopez, in cause 653434, on the motion to revoke community supervision, how do you plead, sir?
True, Your Honor.
Ms. Gross, would you please advise the court and the parties of the status of Mr. Lopez's probation in cause 653434? I remind you, you're still under oath.
Yes, Your Honor. Mr. Lopez has been reporting as directed. We last saw him March 21st, 2021. He has paid $882 towards his fees. He has a balance of $256 and is delinquent $106. We have no proof of completion of any of his 60 hours community service or his firearm safety class. He's had one positive drug test that was for marijuana that was within 30 days of him being placed on probation back in July of last year. Since then, he has had 5 negative drug tests and he has failed to submit on 2 occasions. His prior arrests include a possession of marijuana and the unlawful carrying of a weapon, which we are here on today on 2 cases. This is his first violation report, first MTR, and his officer is recommending that he be placed on weekly drug testing.
Mr. Arce, in cause 653434, what are you requesting?
We conferred with the state, Your Honor, and we would like to have 4 consecutive weekly UA tests. And if he tests consecutively clean, we will then continue his probation, Your Honor. And he has submitted proof of the 60 hours, which was done in a $600 donation, as well as submitted proof of the firearm safety course to the probation officer, Dan Uvalli.
And state recommendation on cause 653434, please.
Weekly UAs, Your Honor, and substantial compliance within 10 days.
When is the last UA we had on Mr. Lopez, Ms. Gross? Susan, can you hear me?
I believe she's on mute, Judge.
Oh,
Yeah, it's gonna take me a second to log on to that website. Give me just a second, Judge.
sure.
That way I can get you the up to the minute information. Okay, the last results that we have on file were from a drug test that occurred on March the 14th. And that was negative. So his original positive for marijuana was on August 6th of 2021, which was shortly after he was placed on probation. And then his next 5 drug tests have been clean, the last one being on Valentine's Day.
This motion to revoke community supervision was filed on or about, it would appear, January 26th, and it's now April 13th. Why does it take us so long to hear this MTR, I guess is the question.
Probably because he didn't get arrested and it's a bond case. I don't know.
He went on probation July 8, 2021 on both these cases, it would appear.
Yes, Your Honor.
And in January and December, I'm sorry, December of 2021 on the 13th, and on January 2022 on the 13th, we have failed to submit to drug testing. And a positive for marijuana on August 6, 2021, which was
That was about 30
shortly
days.
after he pled in, it would appear. So that was within 30 days of pleading in. Does that sound right?
Yes, right around that time frame of 30 days, Judge.
And his last UA was on March the what?
No, Valentine's Day, February the 14th, 2022 is the last one I show in the lab website.
Why isn't there a March UA? Do we know?
I don't know. I don't have that answer. Let me look and see if he was sent. The officer did write that the defendant is to submit to monthly UA testing. So, and that was on March 21st. So I don't know why the defendant did not go.
RC, give me some insight into Mr. Lopez's life. Is he married? Does he have kids? Is he working? What's going on with Mr. Lopez?
He's 19-year-old, Your Honor, and he's currently working at Big Old Tires at a mechanic shop 5 days out of the week, Tuesday through Sunday. He lost his mother in December, and that's why we have that missed date here for the testing. And he's just trying to get back on track, Your Honor. Sorry, he's 22.
Why are we carrying guns? Have we got an answer for that one?
No, Your Honor. And then on March, I believe he tested privately at a private facility. I can get the court record of that as well, which he tested negative.
I'm sorry, at a private facility, meaning that it wasn't
I believe
a county
Texas
order
Med.
facility?
Yes, Judge.
Why,
I believe it was
why did
Texas
he,
Med Clinic.
and why did he take a private UA instead of a court-directed UA?
I believe he was worried about his outstanding warrant, Judge.
And we have no record and have not received anything in regards to that drug test. I don't see anything on file unless it's in the officer's email box.
Yes, Dan should have it. I can re-forward it to the court now if needed.
Mr. Arce, give me some insight into why Mr. Lopez failed to resubmit the drug testing on January 13th, 2022 and on December 13th, 2021.
Yes, Judge. So,
missed it.
yes, Judge. So in December, he was currently switching probation officers, is what he told me, and as well as losing his mother. So he missed that date there. And on January, he just missed a day late. So he's only off Sundays and Mondays. He went in Tuesday to do the screening, but they didn't count it. They counted it as a missed day.
Mr. Lopez, you're about this close to going to jail for a couple of years, and I'm trying to be very, very careful and look at every possible aspect of your probation in your life before I make that decision.
Thank you, Your Honor.
Are you a high school graduate, Mr. Lopez?
Yes, sir. And I went to college for 2 years.
Okay, Mr. Arce, can I ask your client a question about why he's carrying these firearms? I mean, this is kind of unusual because it's not just one incident of carrying a firearm. It's 2 incidents of carrying a firearm. So for some reason, we think we need to have a firearm.
Yes, Judge.
What's going on, Mr. Lopez? Why are we carrying firearms?
Just paranoia with everything that happens in Texas.
I'm sorry, paranoia with everything that happened about what? I'm sorry?
In Texas, with all the shootings and stuff. It's no real explanation, though, Your Honor.
Are you a member of any kind of gang or something that you got to have a firearm to protect yourself kind of deal? What's going on with that?
No, sir, and I do not carry anymore.
Susan, do we have the actual dates of the offenses, of each of these offenses?
I can get them for you if you give me just 1 minute, Judge.
Let's look at that real quick.
Okay, in case number 638886, the offense date was May the 6th of 2020. And case number 653434, the date of offense was January 5th of 2021.
So, Mr. Arce, best I can tell, Mr. Lopez was arrested and charged with unlawfully carrying, I'm guessing a handgun, I don't know what it was, on May 5th, 2020. And while those charges were still pending, on January 5th, 2021, he was rearrested for the same crime. Does that sound right?
Yes, Judge. There's another attorney on that case, but from my understanding, that is correct.
Okay, I got it. State, did I get your recommendation?
Well, I'm not sure, Your Honor, but our recommendation is weekly UAs and substantial compliance within 10 days.
Mr. Lopez, and call 653-434. The court accepts your plea of true. I grant the state's motion to revoke your probation. I sentence you to 6 months in the Bexar County Jail, assessing a $500 fine plus court cost credit for time served, time and money to run concurrent. This case to run concurrent and not consecutive was 653-434, meaning that you'll be serving the same time for both cases, although I have the authority to stack them and make you do one and then another. My last understanding of what the sheriff's quotient for jail time is 3 for 1. I don't know what it is currently, but I do not object to the sheriff giving maximum jail time credit for Mr. Lopez. I show him to have 1 day credit on this case. And he's going to report to the Bexar County Jail on Monday, the 18th of April at 9 a.m. to serve his sentence. Anything further from the state of the defense on Mr. Arce and 653-434? I'm sorry, Mr. Lopez.
Your Honor, the defense attorney, Chris Arce, for the record purposes, I would like the court to reconsider, Judge. This is the first MTR filed for Mr. Lopez. The initial MTR was filed nearly 6 months ago. And if you think that if the MTR was filed, he would have absolutely no reason to further comply, Judge. He went on and continued to further comply with his drug testing. In January, he was only 1 day late from his drug testing, Judge. Further, in August, that was the initial month after that he was placed on probation. So there's an argument to be made there that there's a possibility that the whatever marijuana was in his system was still in his system at the time of the original date of offense. I could understand if he was, out on the streets, not doing anything good for his community, but he's working nearly 5 days a week, Judge. He's so young at this time. I think implementing any type of sanction or jail time for him would strictly hinder the future of his career, Judge. It is both the probation officers, along with the state's recommendation that he would be continued. He would be completing satisfactorily in July. We are not in any disagreement that he could be placed on weekly UAs in order to comply and to please the court, Your Honor. And it would just severely hinder his future and his employment at such a young age, Your Honor, if he were to be incarcerated in the Bexar County Jail for any term of months, Judge. On his own volition, he hired us and asked us to take care of the warrant, because once we found out that there was a warrant involved and no bond and remanded without bond, we then filed our motion to set a bond and even offered and talked and had discussions with probation and also the state in order to bring him in person today if that was going to be any issue on the state side. That was neither an issue then and nor is it an issue now, but we've had significant contact with Mr. Lopez, and we don't believe that he should be sentenced to any type of jail time, Your Honor. We would ask this court for mercy at this time, Your Honor. He's such a young adult at only 22 years old and working full time. We would ask this court to grant him mercy and go with the state's and the probation officer's recommendation and continue him until the satisfactory completion in July, Your Honor.
I want him to live to be 23 years old, don't you?
Absolutely, Your Honor. But as we well know, that there's no crime for carrying a weapon inside of your vehicle, Judge. I don't know the exact terms of the arrest on the first or second unlawful carrying a weapon, but it's not illegal to carry a weapon in your vehicle, Judge.
Why are we here? Why was it unlawfully carrying? I mean, he's on probation for these two cases.
Again,
I agree with you wholeheartedly that unless there's something else criminal going on or something that theoretically an individual in Texas can carry a handgun on or about his person in a vehicle. I agree. But I've got two cases and somebody somewhere down the line assumed or proved that they were unlawful when he had these two weapons. So I'm listening to you.
I cannot.
Why are we here?
I don't know the facts of the first two cases, Judge. I'm assuming that the first one had to do with the possibility of marijuana in the vehicle at the time. At that point, it would be illegal to carry a firearm in the vehicle along with any types of drugs or narcotics. But the second one, Judge, the MTR, again, just going based off the facts of the MTR, Judge, the MTR is for failure to comply with his weapons class, in which he's completed, in which we've sent over the certificate of completion for, and he no longer carries a weapon, and also for the non-testing, in which he did test just a day late. Now, if the MTR stated additional facts, or if it was a positive finding of the drug analysis sooner to this date, Judge, then I would 100% probably agree with your determination that he needs to serve some time. But he's been clean, Judge. He's been clean since August, the month after in which he was placed on probation. He has followed, he's complied, he's completed his community service hours by making a substantial donation in lieu of the community service hours, so that way he could continue to work, Judge. This is not a bad kid that's running around on the streets, with guns. This is someone that made a mistake and is willing and trying to better his life, Your Honor, and turn his life around.
Anything further?
Your Honor, again, we would just re-urge and beg this court to show Mr. Lopez some type of mercy and go along with the probation officers and the state ADA's recommendation to continue him in completion in July, Your Honor. He's so close to completing it. If he were to serve any portion of time, he would more than likely lose his job and basically have to start all over. We're hoping that this court could show him mercy, considering that this is the first MTR that has been filed, and he's been in pretty much substantial compliance with all the other terms and regulations, minus being a day late. With that, Judge, nothing further.
Judge, if I may.
Sure.
I've been reviewing his record while y'all have been discussing things, and Mr. Lopez was made aware of these warrants in his routine office visit, which occurred on February 14th, 2022. He was told to get them taken care of. So obviously he did not do that. So that's why it has taken many, many months to get him here today. And his warrants are still active at this time.
And in response to that, Your Honor, we reached out to his probation officer immediately as soon as we were hired and filed in our notice of appearance and tried to clarify that and to determine whether or not we would be able to do a walkthrough with Mr. Lopez in order to get the warrants lifted, Judge, so that way we could have this MTR hearing. If you'll see my notice and filings on file, they are pretty much within, I would say, days of when he was known of the warrant.
Okay, we're ready to proceed to cause 6388886. I'm
Yes,
sorry,
Your Honor.
it'd be 653-434. In cause 653-434, we've already identified the defendant's consent to motion to revoke hearing by video conference signatures from both Mr. Lopez and Mr. Arce. We've already identified signatures in cause 653-434 on the trial court certification of defendant's right of appeal. And my understanding is that in cause 653-434 on the motion to revoke community supervision, this also will be an uncontested motion to revoke community supervision. Is that correct, Mr. Arce?
Yes, Your Honor.
And Mr. Lopez, in cause 653-434 on the motion to revoke community supervision, how do you plead, sir?
True, Your Honor.
And Ms. Gross, is there any variation on the theme between the probation performance of Mr. Lopez in cause 653-434 from what you've already represented his performance to have been in cause 6388886?
Everything is pretty much the same except for the fees. There was only a fee amount of $20 as you ran the case concurrent with the other case. And that case, or this particular case, is paid in full. Otherwise, everything else is the same as far as what we have records of, and the same recommendation, Your Honor.
And defense, do you have any different recommendation on this one than you did on the last one?
No, Your Honor, I believe we spoke with the ADA and they're in agreement with both to be continued till July with weekly UAs, Your Honor.
And state, is your recommendation the same on cause 653-434 as it was on cause 6388886?
Yes, Your Honor. On both cases, we recommend weekly UAs and substantial compliance within 10 days.
Mr. Lopez, in cause 653-434, the court accepts your plea of true. I grant the state's motion to revoke your probation. I sentence you to 6 months in the Bexar County Jail. Assess a $500 fine plus court costs, credit for time served, time and money to run concurrent. This case to run concurrent was 6388886. And you're to report to the Bexar County Jail to serve your sentence at 9:00 a.m. on Monday, the 18th of April. Now, all that being said, just to advise both Mr. Lopez and Mr. Arce, and Mr. Arce knows me very well, so I'm kind of amazed that he doesn't recognize the significance of my judgment in these two cases. Probably the most serious case we have in any misdemeanor court is unlawfully carrying a weapon, especially a firearm. And I think we all recognize that. I have a circumstance where I have an individual on two separate occasions. The second one, while the first one was pending, carrying a firearm unlawfully. Those being said, and Mr. Arce is very clear on this, I have the authority to sentence Mr. Lopez to 1 year on each of these cases and run them consecutive, i.e. stack them. So you would actually be doing 2 years in the Bexar County Jail. But I recognize, as your defense counsel has clearly pointed out, that you have done some good things on your probation. So I gave you credit for that. I gave you 1.5 years in jail credit for that. So that's why you're only doing 6 months concurrent with each case instead of a longer period of time. So I wish Mr. Lopez the best, and I'm sorry he didn't place himself in these circumstances, but I'm protecting the people of Bexar County, and that's the way it is. Anything further from the state of the defense on Mr. Lopez?
Nothing from the state, Your Honor.
Your Honor, may I have a minute just to re-urge the court one last time?
Sure, absolutely.
Your Honor, if there were an instance in which there was another gun violation during the during the probationary period, Judge, I would agree. And yes, your history of sentencing is on par throughout the last decade that I've known you and been in front of your court, Judge. It is just, this is not our typical client that has a misdemeanor gun charge, Your Honor. Most of my clients that were in front of you previously had some other type of criminal relation or criminal connectivity or affiliation with other gang members, different instances, Your Honor. This is not the case with Mr. Lopez. Mr. Lopez is a very young adult at 22 years of age and a very hard worker, Your Honor. We would request that this not further hinder his life, as in July, he would be completed with all of these cases. He would be completely done. Now, if it were an instance in which he got stopped and had another gun violation, then at that point, Your Honor, I think that your sentencing would be on par with your previous history and rulings. But on this instance, Your Honor, there's just, I don't see the actual reasoning for having him spend 6 months in jail. For the reason the basis of us being here is for 1 day late of testing, 1 positive testing 30 days after he was placed on probation, which we can consider a baseline as we normally do in any other case when a drug offender is testing. And it just doesn't add up, Your Honor. And I'm not trying to be disrespectful to the court at all. I'm just trying to re-urge and show the amount of belief that I have in Mr. Lopez to comply, to successfully comply, to rehabilitate himself to a member of this community that is not only going to be hardworking, but, you know, not lead him down the path that other clients have been with rates of recidivism and whatnot. So again, Your Honor, we are begging the court and asking for mercy for Mr. Lopez to not have any jail time, any amount, Judge, because he will lose his job and he'll get basically starting from scratch. Not only with that, but he'll also have these convictions on his record as unsatisfactory completed probation terms. Therefore, it's going to be even tougher for him in the future to try to find gainful employment. He's not a flight risk. He's not a risk to the community. He's got family, substantial amounts of family here. He's got a good support system. There's no doubt in my mind that maybe he was running around with different friends at that time, but he has since then changed, Judge. And I don't know any other way to explain it, but I would just ask that if given the opportunity at this point, Your Honor, I would even accept an additional 6 months on top of his current probation, put him on until December. And let's see how he complies, even if it's weekly UAs until December. I would prefer that because I have so much belief in Mr. Lopez, knowing that he has turned his life around, knowing that he will successfully comply with any terms of probation that you ask. I'd rather you throw all the terms of probation on him, Your Honor, than have him serve any time in Bexar County Jail. And again, I don't want to take too much of the court's time, but I would just like to re-urge and ask this court to reconsider placing him in Bexar County Jail, Judge.
Thank you, Mr. Arce. Y'all are dismissed. Thank you.
Thank you, Judge.
Your Honor,
Yeah.
I received an email from the coordinator of County Court of Appeals at 11:35 stating that Mr. Gibbia was doing voir dire.
Well, good. That takes care of that.